Here's the brief anatomy of a criminal charge in the province of Ontario, Canada. There's an arrest by a police officer or police officers who gather evidence. Then the charge is laid. It's against the individual. The individual has a bail hearing if need be, or the individual is released. On the day of first appearance, the individual is handed what is called disclosure. The disclosure is the evidence that is going to be used or proposed to be used by the Crown. The Crown is the prosecution to actually prosecute the client, and that will include things like the statements of witnesses, if any, the evidence of the complainant, the evidence of video evidence, if one exists, as well as any other evidence that they intend to use for purpose of a prosecution. That document which is the most fundamental document, is the one that we use for purpose of defending the allegations. Once we get to the first part of this whole process, which is what is called a Crown pre-trial, this is where the defense lawyer as well as the prosecutor try to resolve the matter if possible. If it is not possible, then it goes to the next level, which could be what is called a judicial pre-trial. This is a trial or a mediation before a judge who is not going to be the trial judge if the matter were to proceed to a trial. If the matter were dealt with, it can be resolved at that stage. And if it is not, then the next level is putting the matter over for a trial. The trial will be many, many months outside the date of initial arrest. The prosecutor's office is a well-staffed office. It's got more technology than most lawyers' offices. However, prosecutors' offices are notoriously afraid of lawyers who have no fear of taking the matter to trial. And that's where, when you're looking for a lawyer, you should be looking for a lawyer who has trial experience in actually taking matters to trial where the need arises.